The AI Act defines the concept of the artificial intelligence system in a broad and technology-neutral manner, also inspired by the OECD definition. An artificial intelligence system is described as a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. These systems may include machine learning technologies, symbolic logic, neural networks, rule-based systems, optimization algorithms, and other intelligent automation methods. The AI Act applies to any software or system that falls under this definition and is developed, placed on the market, or used within the European Union. The regulation applies to different categories of actors involved in the life cycle of artificial intelligence systems. In the first place, we have the suppliers, defined as anyone who develops an AI system and places it on the market or puts it into service in the European Union under their own name or trademark, regardless of where they are established. They are responsible for ensuring that the systems they produce comply with regulatory requirements, especially for high-risk systems. Then we have the users, defined as persons who, as part of their professional activity, use an AI system within the European Union, whether natural or legal persons. Finally, we find distributors and importers, which are entities that facilitate the availability of AI systems on the European market. The aim is to ensure that all actors comply with the security, transparency, and governance requirements of the regulation, creating a reliable and secure digital single market. The AI Act explicitly excludes certain categories and areas from its scope of application in order to avoid regulatory overlaps or for reasons of specific competencies. In particular, the main cases excluded from the application of the AI Act include AI systems that are placed on the market, put into service, or used with or without modification exclusively for military, defense, or national security purpose, as well as those that are not placed on the market or put into service in the Union if the output is used in the Union exclusively for military, defense, or national security purposes. The reason for this exclusion is that the use of such technologies is subject to specific regulations. AI systems developed or used exclusively for personal, non-professional purposes. These systems are excluded because the regulation aims to regulate professional and commercial use of AI, not private and domestic use. AI systems used exclusively for scientific research or experimental development, provided they are not placed on the market or used in commercial or public operating context. AI systems that are not placed on the market or put into service in the European Union, thus outside the material and territorial scope of the regulation. Finally, the AI-generated content, since the regulation focuses on AI system per se, not on the protection of copyright or AI-generated content, which is the subject of other legislation. Article 25 of the regulation regulates liability along the AI value chain, stipulating that every actor involved, suppliers, distributors, importers, deployers, and other third parties, may be held liable and subject to compliance obligation under specific circumstances. According to Article 25, a distributor, importer, deployer, or other third party may be considered a provider and thus subject to all compliance obligation if it affixes its name or trademark to a high-risk AI system already placed on the market or in service, unless there is a contractual agreement assigning such responsibilities otherwise. If it introduces substantial changes to high-risk AI systems already marketed or in use, and if it modifies the intended purpose of an AI system, which has not been classified as high risk and has already been placed on the market or put into service, in such a way that the AI system concerned becomes a high-risk AI system. In these cases, they must ensure that the system complies with the requirements of security, transparency, risk management, and the protection of fundamental rights laid down in the regulation. The principle of accountability along the AI chain dictates that each actor assesses its qualification under the definitions provided in the regulation by reason of its actual activity on the AI system, verifies and ensures the conformity of the AI system with the applicable standards in proportion to its subjective qualification, take responsibility for its own actions and decisions concerning the use, modification, or marketing of the system, and collaborate with other actors in the chain to ensure safe and reliable use of AI. This approach aims to avoid accountability gaps and promote shared and transparent management of risks associated with the AI systems, especially high-risk systems, thus protecting the health, safety, and fundamental rights of European citizens.